Okay, Craig, it is so great to connect again. I think the last time I saw you was probably at graduation, but I have been reading about you in the news because you've had a number of successful cases. And so it's so great to be able to chat with you again today.
Yeah, likewise. I mean, I remember, watching The Bachelor with you and your wife, me and my wife, back when you only had one kid, and this is probably back in like 2011, 2012, I think,
So,
like that.
and The Bachelor, I loved watching The Bachelor. Had a friend on The Bachelor at the time who won. Jeff was 1F. He won. And then also, I remember playing basketball with you as well. So
Oh yeah,
we got
that's
in
right.
lots of basketball at Arriaga.
Yeah,
Well,
that's right.
so you're now a trial attorney, and I'm curious, uh, at what point did you decide you wanted to be a trial attorney? How did you choose to be a trial attorney?
Yeah, I'm not sure that I ever really decided to seek out trial in particular. I think it's something that more evolved after I got into law practice. I think what attracted me to law school is I had done debate in high school, Lincoln Douglas debate, so one on one. I did that for 5 years from eighth grade to 12th grade and enjoyed it a lot. Had some success, and I guess I kind of saw law as being the most analogous to debate. And in litigation, where I practice now, bringing lawsuits, defending people or companies when they get sued, it's sort of like the debate Olympics. It's like there's traditional things like that are quite similar to debate, like doing an opening or a closing argument in a trial. But then there are all these other little events. There's like taking a deposition, defending a deposition, interviewing a fact witness, um, strategizing and negotiating with the other side over the exchange of documents and information. Writing briefs, working with experts. There's 20 or 30 different common tasks that certain people excel at different ones, and there's a lot of variety, and I like that. I think the trial stuff I've just gravitated more. I think I would say probably most lawyers are kind of either more into the law and thinking about legal questions, and maybe therefore more interested in writing fancy briefs. And then there are some who are kind of more into the facts and like telling factual stories and taking a set of facts, pulling out the best ones, kind of massaging the ones that are a little more challenging and presenting a compelling narrative. And if you're like that, and I'd probably put myself more in that camp, I think that draws you more toward trial work. So that's where I've kind of moved more toward as I've gotten further out of law school.
So I wondered if you had done debate in high school. I figured you had, but I didn't know for sure. When I graduated undergrad, my very first job was selling medical device. And most people don't even know what this career is. I certainly didn't before I got recruited into it. But you are basically in the OR with the surgeon as they're performing. I was doing a orthopedic, so total knee, total hip replacements. So I'm standing there in the back with, maybe a little laser. I'd provided all the instruments and implants for the surgeon to do the surgery, and they're like to do a hip replacement. The first thing they do is they dislocate the hip, and then they saw off the femoral head, and then they do a bunch. You got drills and bone saws and cauterizing, and it was just like I am in this world that very few people get to be. It's just like a totally different world, right? Like you can't buy your way into this world, and it's just a different world. And I imagine that's a little bit like what you're doing. You're in this world that so many of us like we see on TV, but like prepping a witness, that's like a whole kind of that's a whole experience that 99% of us are never going to experience. Arguing in front of a judge, you know, saying I object. All of these things to me, it's like you're part of this really cool world that you can't buy your way into, and the very few people get to experience.
Yeah, I mean, I certainly I think it's fun. I mean, it's I think one thing about it that I guess I wouldn't, I didn't give it a lot of thought going into it, but one thing I find that I enjoy a lot about it is that these big trials where there's a lot on the line, it's a team sport. You have your team and you're going up against the other team. And there's a team that is much broader than the attorneys who are giving the arguments or examining the witnesses. Um, it starts there with the leaders of the team, but then there are more junior attorneys who are, doing the first drafts of examination outlines and working with witnesses, working on what the jury instructions are going to be, briefing various disputes that go before the court. And then you have, paralegals who are doing a lot of document work, or you have a hot seat person who is a technology person who's running through the exhibits and the video or the other slides that are up on the screen and coordinating everything if you need to impeach someone's testimony. So one thing that's really satisfying about it is I work at a great firm, and I get to work with a lot of really extraordinarily talented people at every level of the team. And it's really fun to compete on really talented teams. And then if you're lucky enough to win it with a great team, it's a lot of fun too. So that's probably the most satisfying part about it, is just getting to work with really great people together to try to get a result.
That's interesting. I hadn't quite thought of that. As a kid, thinking about an attorney going to trial, you just envisioned like one person. You got this one attorney that represents the client, and then over time realize, oh, it's a team. But wait, hear you describe it. This team is even much broader than I had realized. And so yeah, really, really cool benefit that I hadn't thought of. Okay, so you take cases to trial. Is there any way you could possibly distill, like, what is it like to take a case to trial?
Well, I mean, oftentimes in civil practice, which is what I do, I'm not a criminal prosecutor or defense attorney. So generally the cases I'm involved in are civil cases. And in general, it's, one of my colleagues like to say it's irrational to take cases to trial,
Mhm.
because usually there are disputes about money, right? And so, if the two sides are being relatively honest with themselves about the strengths and weaknesses of their case and the strength of the evidence and what the law is, sophisticated lawyers should be able to handicap that relatively well, and get a sense of who's going to win, and if a certain party is going to win, how much money they're going to get, and negotiate a resolution, because the trial itself is a huge cost to both sides, and it's really expensive for the lawyers to spend that much time working on the trial. And so the cases that do go to trial, it tends to be for reasons where, one party or another is there maybe emotions involved. And maybe, or one side or the other is not rationally estimating their chances. Um, Sometimes cases go to trial because it's really about principle. I would say that was the case with the case I tried for, uh, Vanessa Bryant, Kobe Bryant's widow, against the cops and firefighters who took and shared these photos of the victims' remains. Um, and um, and so, it's certainly the exception to the rule to have cases go to trial, but usually it's kind of a circumstance like that, where um, it's either not about money, or one side is just kind of not being rational about the situation.
So when you prepare for a trial, you talk about these maybe 30 different team members. Is that what you said? 30 different processes?
Yeah, I mean, it varies. I mean, I would say of the recent examples I have, the teams here might be maybe 20, 12 to 20 people who are
Okay.
involved in the endeavor. You could certainly have firms where you might have teams of 30 or 40 people. Maybe half of those are attorneys, or a third of those are attorneys.
Do you have a favorite time during trial prep, like whether you're prepping witnesses, taking depositions, or do you just kind of enjoy the whole process?
Yeah, I mean, in my view, there's really nothing like giving a closing argument or an opening argument. And when you just have the floor to yourself, and you get to, um, I have a pretty much an uninterrupted opportunity to craft your message to the decision makers. That's pretty fun. In other phases of the case, even if you're examining your own witness, you're not in total control. It's kind of like a dance. You can practice the dance somewhat, but when it goes live, you don't know exactly how it's going to go, and it's not totally within your control. And then obviously, if you're cross-examining an opposing witness, it's not totally within your control. But giving a closing argument is a lot of fun. So that's probably my favorite part.
So I played a lot of sports growing up, and baseball wasn't my favorite sport, but pitching was that was the first thing I thought of when you talked about making the closing argument. Like you got the ball, all eyes are on you. You're kind of in control in that moment. As a batter, you don't know what's going to happen, but as the pitcher, like you initiate the play. And so I could imagine that closing argument would be a rush. Just a question came to mind. Are you totally memorizing the closing argument? Are you practicing? Are you performing? Like, what's that process like?
Yeah, so I don't write down every word. There may be parts of it that I write down in their totality and that I just but I never read from a script. So I might practice certain key portions so that I get the wording exactly as I want it. But for the most part, I just have the concepts that I want to hit. And either I have just extremely high level bullets, just to remind myself not to miss an entire point and skip over it, or I'll have slides that I'm not reading from, but that are in front of me, and that kind of guides me as to the high level points that I want to make. Um, in closing argument, oftentimes I'll have slides showing, pieces of testimony or key pieces of evidence, so that the jury can just, I'm proving it to them at the same time that I'm summarizing the evidence that came in. They can just see it right there in front of them. But I think in general, it's best to not be too committed to a script or kind of precise wording, because authenticity is key. And I think it's much better. It's much more important, rather than having every word just precisely scripted, as it is to just make an emotional connection and a human connection with the jury. And it's easier to do that if it's somewhat extemporaneous. You have an idea of what you're going to say, but not every word is chosen in advance.
That makes a lot of sense. When I was in probably it was the second or third year of law school, taking this tax class from Joe Bankman. Joe invited all the students over to his house. I loved Joe's class. And I was in his library and I asked him, I said, one, can you remember all the books that you read? Because he had a ton. And two, if you can't, does it bother that you can't? And he said, well, I just actually read this really cool book on memory called Moonwalking with Einstein. So anyway, I read this book and I loved it. And it's written by the U.S. This journalist who eventually becomes the U.S. memory champion, and he talked about using memory palaces. And so I want to like give a speech, and so I wondered if you were using memory palaces where you place like a specific topic in your mind at like the front door of your house, and the next topic in your living room, or if you were using slides, or if you were memorizing it. So it sounds like definitely not memorizing word for word, but yes, memorizing kind of topic for topic.
Yeah, I mean, I think that by the time a case goes to trial, you've typically worked on it for a year or two or three. And so you just know the facts
Mm.
extremely well. I mean, you're able to recite them and craft an argument or what you want to say. You've molded over your head over and over across many years. And it's just like, describing something to your spouse or to someone in a cocktail party conversation. It just flows pretty naturally after you've lived with a case and the facts for that long.
Interesting. I hadn't thought of that, and it makes total sense. So, speaking of cases, what cases are you most proud of and why?
Yeah, so I mean, a couple. I guess the easy answer is the Bryant matter, because there we were doing something that was basically totally unprecedented. And I think the concept was in the Ninth Circuit, which is the federal court that essentially has jurisdiction over California, like the entire West Coast and part of like also like Nevada and Hawaii and Alaska. They recognize a federal constitutional right to control the death images of your loved ones. And there'd never been a case that was tried under this constitutional right before. And the thought process for us was not to try to kind of maximize dollars. It was really about a set of people who were supposed to be holding the public trust and looking out for these victims when they were vulnerable and like couldn't look out for themselves, and instead abuse that position of trust to take souvenir photographs of the victims' bodies and then text them around, show them off in public. And then when we found out that none of these people had been meaningfully punished at all, the trial was a really important way to get some measure of accountability. And it was a way to force all of these cops and firefighters who had done these things, which, mind you, many people responded to that crash scene that day and behaved completely honorably and were tremendous public servants. And so we're talking about a minority here, but to call them to the stand and force them to face cross-examination and to testify in public in a packed courtroom full of press about what they did, and then to get the liability finding, it was very meaningful. And also just to represent Vanessa, I think that she's just an extremely formidable, courageous person. This wasn't something that I think a lot of people would have had the moral fiber to carry forward and just push to its conclusion in this way. I've been part of cases, and it's a common thing that happens in civil matters where you have someone who has a lot of stature or money or power or whatever, and it's coming time where they're going to need to have to give testimony in a case, usually in a deposition, and they want to find a way to resolve the case and have it go away because they don't need it. It's not, they want to spend their time on other things. It creates a lot of anxiety and everything. And with respect to that, and then some, she just never blinked once. And at a tremendous personal sacrifice, she persevered to get that accountability. And ultimately now we have what's like a landmark civil rights decision. And then I think the publicity that surrounded it is something that is gonna, for every first responder, cop, firefighter, paramedic, or whatever across the country who read about that case as it was happening in USA Today or online or whatever, and just knows a little something about that case and thinks twice about doing that, I think that's meaningful because that conduct is really painful to people who experience these tragic losses. So I'm quite proud of that. I had some other cases that I tried as like a on loan prosecutor when I was a associate prosecuting like traffic offenses like drunk driving and hit and run. And I have some convictions I'm proud of from that too, I guess you could say. I once prosecuted this guy who was a mortician, who was an embalmer, and he had driven up to a DUI checkpoint and blew like a .2 on the breathalyzer and was, extremely intoxicated. And his defense had been that he had been embalming bodies all day that day in a room the size of a child's bedroom using formaldehyde, which contains alcohol, and it must have been the inhalation of these alcohol fumes that caused him to blow a .2 on the breathalyzer because he hadn't ever had a drink in his life. Ultimately, the jury did not go for that. So I've had some fun cases, some kind of silly cases, I guess, and others that, are kind of more meaningful. But yeah, those are the ones that come to mind.
Well, I suspect you are going to inspire a number of listeners to consider law school because you can do so much good in the world. And, many students from top law schools get recruited to big law firms, and you're defending billionaires against billionaires, and they need good counsel too. And our system and society needs people, or needs even big business leaders need good counsel to protect their rights. But cool to also hear kind of in maybe more of a personal level how you're able to use your education and expertise to win landmark civil rights cases. So very cool to hear. Maybe last thing as we wrap up, is there any advice that you have for students who might be thinking about law school, or even a career as a litigator? Like, what have you learned that you would most want to pass on to others?
Yeah, I mean, I think law can be like a great profession. I think it's really satisfying if it's a competitive activity. I mean, it's a competition. And so for people who like have a sports background, for example, I was never an accomplished athlete like you, but um, I think people who enjoy the competitive element might enjoy litigation. People who enjoy public speaking and debate might enjoy it. I've found it a lot of fun. I think it's more and more satisfying each year as you kind of get closer to the action, as you put yourself in a position to be the person who's not just supporting trials, but actually trying the cases and being in front of the judge and jury. In terms of how to be effective in trying cases, I think one thing that I learned from being a teacher before I went to law school and from trying cases is that authenticity is key. I think trying to, it's a mistake to try to be a teacher in a way that you kind of think a teacher should act, or to try to be a trial lawyer in the way that you think a trial lawyer should be. Um, and and instead just kind of trying to be yourself and be trying to convey information clearly if you're a teacher and connect with people, to try to convey information clearly and connect with people if you're giving a closing argument to jurors, because I think that's what resonates with them more than anything is someone who they just like and find to be a real person. I think that's what makes them gravitate towards certain lawyers, and it makes them gravitate towards certain witnesses on the stand and make them believe some people more than others. And I think too, probably more so in being a trial lawyer, is just kind of trying to put out of your mind the notion that you're going to impress anybody, that people are going to walk away from this and think that that was so impressive. And I think that one is kind of hard to walk away from, because you have these notions of like A Few Good Men or
Yeah.
whatever, of what you see in movies and TV, of like great oratory or whatever, and people are just going to think this was an amazing delivery. That's really not a helpful mindset to go into it with. And the objective really just needs to be, I'm going to go in and be reasonable and persuasive and authentic and convincing, and get that job done. And maybe people will find that impressive or not, but I think a mistake sometimes that people make is to trying to impress over trying to just do the job that's in front of them. And so that's one thing I'd say that I've learned. And if I was to give any advice to people who want to be trial lawyers, that's probably what I'd offer.
I took an English class in Ephraim, Utah, in at Snow College. Ephraim, Utah is a population of like 2,000 people. And my English teacher there, the one thing I remember from his class was right to express, not to impress. And that just always stuck with me. And apparently you've been able to really apply that as a trial attorney. Your closing argument in the Vanessa Bryant case received a ton of great positive press. You were able to nail that. This has been so fun for me because when we go to law school, it's like, you learn to think like an attorney, you take all these courses, but you don't get much experience into like the actual practice of law. So I think I've learned more about being a trial attorney today than I ever did in law school. And I will say too, you were quite competitive and you were a good basketball player. I remember that. So
Oh, okay, no, no, no,
uh,
no, not
you
not
had
specific.
good, you had good ball handling abilities, and you were a good shooter, and you were competitive. So I would not want to be
I,
competing against you in law.
yeah, I remember, Mark Madsen used to be playing in the gym sometimes. That was the celebrity in there. And then another of our somebody from the class above us was just recently unsuccessfully ran for Senate in Arizona. And so there were some notable basketball players at Stanford at the time.
I do remember I was recruiting, you get to the gym and it's like I'm gonna scout out who my team's gonna be, and I see this big guy walk in.